Hi, good evening, everyone. So I think I've been given the most difficult session. It's the last session where I think everyone's already a bit tired. Oh, we have one more? Oh, I'm sorry, guys. Okay, we have one more session. Okay, not the last session, but the penultimate. But I think the topic which I'm going to speak about is law and regulation. And now because it's law and regulation, I realize that most people are just not interested in it. But I'm going to try making this as interesting and as participative for you guys. So what I suggest is that even while I'm speaking, if there are any questions, please feel free to ask during the course of this presentation. I'm going to ask you all questions and see how it works out, and what are your thoughts on law and regulation and how we should go about this. So just make it as participative because it'll be as interesting as I can make it then. Just a little bit of introduction. I'm Sibal, and that's my colleague Charlene Tiwari. I'm a partner at a firm called Jerome Merchant and Partners. We are a boutique corporate law firm here in Mumbai. We work on the banking and finance side with all the big banks and financial institutions, everyone from Deutsche, KKR, SEB, ICICI. On the tech side and the regulatory side, we work with Facebook, Uber, Circle, Naspers, PayU. So we work with a whole host of these companies. And what we've come to realize is our blockchain practice is really stemmed from the last couple of years. It's a pretty young practice area, given where we're at in the space right now. We are also the preferred legal advisors to the bank chain community. I don't know if everyone knows about that. It's 35 odd banks here in the country where they've come together to see how to implement banking solutions using blockchain. For example, KYC, cross-border. Those are some aspects which the bank chain community looks at. Out there, we're part of the regulatory committee, which helps in formulating regulations and interacting with the government. So now, very quickly, you all had an entire day talking about blockchain, so I'm not going to give any further introduction. But I think the idea of blockchain technology is fourfold. It's firstly to reduce costs, reduce transaction time, eliminate intermediaries. I think these are and most importantly, the transactions are immutable. So I think these are the four most important aspects of why we want to implement blockchain technology. Now the first question which I want to ask everyone, when we're talking about regulation and when we're talking about laws, can we regulate blockchain technology? That's a question to you. Anyone has an answer? No. Right. Right. You can't regulate blockchain technology, right? I think that's one aspect which has to come out very clearly. You cannot regulate the technology. So the question is, what do we want to regulate? Or what requires regulation? In my view, it's the application of this blockchain technology or whatever solutions we come up with. Those solutions really have to be regulated in some manner. A small example, in the bank chain community, what we're working with is sharing of KYC information between banks on using blockchain. So now that solution, we really have to see whether it fits within our regulatory framework or whether any amendments are required. Or another question to be asked is, do we need a completely revised regulatory framework? Do we need new laws coming into place to make sure we can effectuate or these solutions can really come into place of how we perceive them to be? Let's move on. So now, just quickly, given that we understand that we're not going to regulate the technology, but we're going to regulate the solutions using this technology, I think one person from the government was here earlier. So could you all tell me what the government position is? Because someone just finished talking on how to regulate this. Anyone? We just had a mighty official here.
They want the industry to come with a solution or do self-regulation kind of thing.
Right. So basically, not too much right now. That's the way I would say it. I don't think the government official is here anymore. Yeah. Not here. Yeah, so effectively, what our government approach has really been has been a bit more of a wait and watch approach. Now, in my view, that's not necessarily wrong. not to defend a government or to defend a regulator, but I think we have to be very cautious as to how we regulate this technology and how we're regulating these solutions. And the reason is over-regulation will stifle development and any technological advancement. Under-regulation will put them in a position which they don't want to be, because then it can lead to a lot of discrepancies, which regulators will keep pulling up people on when there's no clear law. So therefore, I think, while I'm not saying that's the perfect approach, I think it's a cautious approach trying to understand what's happening in the market and then formulating something. Because overreacting or underreacting, that's no solution. I'll give you an example also why I'm saying this. If anyone is keeping track of things, we have a new insolvency code which has come out last year. Now, sorry? NCLT? Yeah, so the NCLT, you have the insolvency code, bankruptcy code, which is there. Now, bankruptcy. Now, we've discussed this for probably 100 years. We know what bankruptcy is. We know what the code is. We know what insolvency is. We have companies which have gone insolvent. The Companies Act 1913 had it. Companies Act 1956 had it. 2013 has it. And now this insolvency code is there. Even for something as insolvency, we're still grappling as to how to practically apply it. The government has been. So if you've been keeping track, you see every month there's a new clarification coming out or a new amendment to the law coming out, because there are practical difficulties which were not foreseen at the point of time of formulating this law. I'm not saying that's correct or that's always the case, but as something as understood as insolvency, that was an issue. Now moving on to blockchain. Now, given the lack of information which is there or the lack of understanding which possibly could be there, for the government to formulate something, I think it'll serve us worse than what it should, than the actual outcome. So now just quickly, what I want to take you guys through is the way in which a regulatory framework should work, okay? There are three main categories, and I'll take you all through it. One is called recycle box, other one is called black box, and the last one is the most fun, is called sandboxing, okay? What is recycle box? Recycle box is essentially solutions using blockchain technology whereby we do not need a completely new law. All we require is certain clarifications or amendments to the existing regulatory framework, and we can implement these solutions. And for this, I'm going to give you the same example, KYC. For banks to share KYC information using blockchain technology, we really need no new law, right? That can already be done. The only question is whether the sharing of this information is consistent with data privacy laws, whether there's informed consent given by the clients and the customers, and the manner in which a bank can rely on this KYC information. So we have an existing regulatory framework. The only thing which we require to change or clarify is the manner in which it's done. So there's nothing new really required in the recycle box. The next thing is the black or dark box. So hopefully I'm just going to skim through this for the sake of completeness, because I don't think it's relevant here. This is basically doing something patently illegal. For example, selling of drugs. Okay, so we had Silk Route, which traded in drugs. So when we talk about a regulatory framework here, we're really talking about having new modes of enforcement to ensure that government agencies can work better to track down such patently illegal activities. Come on. Okay. Coming to sandboxing, someone mentioned that Deloitte was here. Anyone from Deloitte still here? Oh, they just left? All right. So Deloitte has been working, I think, on sandboxing. Did they speak earlier? No? Okay. So I think Deloitte was working with the government on creating a sandbox. Now, what is a sandbox? A sandbox is essentially having a limited market participants in a controlled environment. So you'll have the regulator involved. You will have limited market participants, and you will test out your technology, or you'll test out your pilot project. And then you will see as to its implications. Now, why is this beneficial? Couple of reasons, right? Firstly, it'll give the innovator or the solution provider the ability to test out his product in a less regulated environment, okay? Secondly, it'll help the government understand what this technology is, what's the solution, what is the impact on the entire ecosystem, although it's in a limited frame. So, when I'm looking at sandboxing, the examples I'll really use will be probably a P2P platform using cryptos, or probably raising of capital through ICOs, right? These are all things which should be really within the sandboxing, or within the sandbox environment, because that will help the government understand this technology, and hopefully we'll be able to roll it out afterwards. Now, sandboxing is also not very easy, because you can't just have one government regulator involved. For example, I mentioned ICOs. So if you want a genuine sandbox, then you'll need participation from the RBI, you'll need participation from SEBI, you'll need participation from corporate law professionals, from NCLAT. You need participation from all these regulators really within the sandbox to see and to analyze the solutions which are there. Now, coming to where India is on sandbox, the RBI came out with a paper called FinTech and Digital Banking. So the paper is of November 2017, but it was really released to the public in Feb, last month, early last month. So out there, it's discussed the idea of sandboxing. So it's mentioned it. It's mentioned blockchain. So it said these things are good, but other than that, they've really not said anything. And it's a 240-page paper, okay? So 240 pages of working paper from the government, which essentially says blockchain good, sandboxing good. What is other? And then they go on to mention every other country which has really implemented what sandboxing and blockchain technology. So, they've referenced laws in Singapore, Australia, the UK, and used them as examples. But what they really didn't say too much in that document is whether we'll be moving to something like this, whether it will be implemented here in our country, what is the actual regulatory framework which they want to deal with the situation. So, while it's a paper which is a good summary of everything, I don't see an actual view which was taken in that. So that's the regulatory framework which we're really looking at. Sorry. I can't hear you, sorry. Sorry about that. I can come there actually, no problem.
So in UK, they are going for private data exchanges.
Yeah, I can hear you.
And it's a common law country. So is it something which is of interest to, how is it is being looked at? Because private data exchanges are coming especially for sharing data between two companies on a secure basis.
Correct. Yeah. So just to answer that question as to whether our government is really, contemplating that, what they did come out with was a white paper on data privacy. I think that was a couple of months ago, right, Charlie? So they came out with, again, a white paper on data privacy, saying how you should share information. Long story short out there, because again, it was a massive paper and the regulations are not yet formulated. They've actually taken, and we were one of the participants who gave comments on that working paper to draft the regulations. So regulations are going to come out, but the basic concept there is whether, and just really long story short, is whether it's informed consent. Okay? So how that consent is obtained from the individual and how it's utilized. I think that's what it really boils down to, whether you have to take it upfront, the manner in which you take it. Once you overcome that hurdle, then yes, you can share information and you can have these data exchanges.
Are you guys following up on UK example? Because UK is the first country, I think, where they are looking at private data exchanges.
Right. No, correct. While UK is looking at it, I don't think the Indian government is actively regulating on that. So if that answers your query, I don't know.
So how does, just to add to this, so how does GDPR come into the picture? Does this impact GDPR?
No.
No?
No. Doesn't. So, like I'm saying, the white paper is there. The regulations are going to come into place. Again, it just boils down to informed consent. Very long story short. That's what it is. So I'll just give you another example. I mentioned KYC, as an example of bank sharing information. So again, for say if I give my information to the bank, KYC, can the bank really be sharing it with other participants? That's one question. Unless it's informed consent, unless in the terms of your document you really say that, yes, I have been permitted, I permit you to use my information in this manner. Okay? So you technically can do it if there is informed consent. Now, what is informed consent? That is a little bit more for debate. But if you tick the box and say, yes, you can share my information, then the banks can actually pass on that information. So that's just something to... Sorry?
UK has adopted GDPR.
Yes, I know that, yeah, absolutely. No, correct, absolutely. So that's on the regulatory framework. Coming just very quickly, I'll just touch on this subject, smart contracts. Everyone knows the concept of smart contracts. Just very quickly, it's a contract which is written in code, it's automated, and it's enforceable. These are the three main aspects of what a smart contract is. With regard to interpretation, there are different ways in which it can be interpreted in different definitions, but essentially it boils down to those three ingredients and nothing more. Now just very quickly, and as an example which I give everyone, a smart contract, the oldest version of a smart contract which I can think of is a vending machine. You put in a coin, you click, say I want a Diet Coke, and you get a Diet Coke out. It's as simple as that. That's what a smart contract really is. Just moving on. Yeah. So now coming to the limitations with a smart contract. A smart contract is written in code, okay? As against, the regular contracts which we have today, which is written in our language, which is easy to understand. At least lawyers like to believe it's easy to understand. So the question is, can the code absolutely capture the entire intention of the contract, right? That is the biggest question to ask. When you're coding, I presume it's more binary. It's either yes and no. You can't have subjectivity there. Having said that, every contract which anyone has probably entered into is always subjective. No matter if it's a rent agreement or it's an equity transaction or a loan document, they are always subjective words. As you'll know, there's nothing black and white when it comes to your contracts that you execute. There's so much gray area. For example, when you go to your contracts, you'll see the word material. Okay? Is there any specific definition for material? Answer to that is no, right? It's subject to interpretation. It's what is material for that document. Okay? So for example, in a shareholders agreement, you'll have a different concept of material. In a rent agreement, you'll have a different concept of what material is. And no one actually defines that term. It is intentionally kept subjective. Now, something intentionally kept subjective, how can we transfer that exactly into code, right? That's where the difficulty lies. Secondly, you'll have concepts such as good faith, best efforts, loose language like this. Those, again, can't be translated directly into code. So that's one limitation with regard to your smart contracts, which we see happening today. Secondly is that, if you go to a lawyer and you ask him, say that, okay, this is what is the document in local language, I want it translated into English, give me a clear interpretation. The lawyer will always be apprehensive as to interpreting the translated document because it's written in a certain way. Now, when we write or when we believe we write contracts, it's based on substantial amount of jurisprudence. So when lawyers negotiate, a lot of people think it's actually a waste of time. Lawyers are probably billing by the hour, and therefore, let them go and argue. But the idea is that we negotiate because these terms have certain significance for us. Okay? It's based on substantial amount of decisions from courts, jurisprudence written by authors and legal scholars, and that's why we negotiate. Now, to take all of that and absolutely translate it into code becomes extremely difficult. We do not know as to whether the code can absolutely capture the intention of what the legal document is meant to say. So that's another shortcoming of a smart contract. Lastly, one of the other most important aspects which we keep mentioning about blockchain technology, smart contracts, is that it's immutable. Now my question to you guys is any contract absolutely immutable which you enter into? Answer is no, okay? It cannot be immutable. And the reason being, it's not you and me who decide whether a contract is immutable. It's actually the judiciary which will finally rule on some matter whether it's immutable. Okay, so unless you have a decision let's play out this example. So if you have a rent agreement which you're using through a smart contract, okay, you say, okay, this is final. It's actually not final because you'll first, if there's a dispute, you'll first go to a city civil court From there, you probably go up to the High Court, depending upon the pecuniary jurisdiction. Then you further appeal it to the division bench. Then if you're really litigating, you go up to the Supreme Court, and they'll finally pass a decision. And that probably makes it immutable. Until then, it's really not immutable. So I think that's one concept which we have to get ourselves or factor in with regard to smart contracts. And lastly, on smart contracts, what I really want to say is that, again, capturing concepts such as representation and warranties, it's not very easy. And I'll go back to the vending machine example. So I put in a coin, I click Diet Coke, I get my Diet Coke. But once I open it up, I see my Coke is flat, or worse, I see there's an insect in my Coke. Then what do I do? So that's a breach of a representation. So although it's executed, that contract, I need to have my legal remedies there. So and that's why traditional legal contracts really help in capturing these concepts. So what is the solution? In my view, short or in the medium term, we're still going to have traditional legal contracts. However, for smart contracts, it's really going to be the operative part. Okay? Things which can be just tick the box, which is yes and no, those aspects can be captured in a smart contract. And we can introduce a concept of wrapping. Wrapping is basically you'll have your traditional contract, which will set out these basic terms, and the operative parts are really coded, and that's executed by a smart contract. So that's basically the presentation which I wanted to discuss with you all today. Does anyone have any other questions on smart contracts? Yes.
So, like the smart contract, though you have partly answered, are they legally tenable and enforceable, sort of?
Sure. Yeah. Now, to answer that question, okay, in my view, absolutely yes. And the reason why I say that, smart contracts is just another way of documenting the understanding between two parties. Okay? So our Indian Contract Act has certain examples or certain ingredients which make a contract or which require a contract to be enforceable. So as long as you're meeting those requirements, such as meeting of minds, valid consideration, the object of your contract is legal and valid, as long as you're meeting these conditions, there's no reason as to why a smart contract will be ruled invalid or unenforceable. Where you have difficulty in smart contract is actually proving execution, whether it's been validly executed, is your digital signature covered within the IT Act or within the Evidence Act. While it would be great to have clarifications saying that it's expressed, but yes, impliedly and conduct would suggest that these contracts will be enforceable, as long as they meet the criteria which is there under your Contract Act.
Okay, and sometimes the stamp paper is required. So here also that is valid, or
no? Correct. So what I suggested was have your traditional contract, okay, and then only certain portions of it will be through a smart contract. Okay. So a traditional contract will anyway be stamped. You'll pay stamp duty on it. Yes. So that concern gets taken care of. I think when we're discussing these concepts, what we have to, at least the way I'm looking at it, we're trying to do something. We're trying to do something differently, and I mean, we're doing the same thing but achieving it through a different mode. Okay, we're trying to be more efficient in regard to this process.
Okay. Can you just give a real-life example of what you just mentioned, just for clarification? You said smart, you have a regular contract and then you have a smart contract as part of it. Can you just give an example, real-life example that would help us understand this better for people who are not from?
Sure. Okay. Just think out loud, say a loan agreement. Okay, so borrower and lender. Your basic terms and conditions regarding your borrowing, your representations, your negative covenants, basically things which you can't do, what constitutes an event of default, your payment dates, all of that is captured in your regular agreement. But your payment mechanism, right? Every time when there has to be a debit made from your account, okay, so that can be that can be automated. So that will be the coded part. So the process which just requires a yes and no, that can be in a part of your smart contract. Having said that, everything else, right? Dispute resolution, easier to capture in your regular contract, arbitration or governing law, representations, subjective parts. Subjective parts capture in your traditional contract. Operative parts is a smart contract. And in fact, your traditional contract will refer to the code also. So you'll say code as referred to in Annexure 1 of this document to reflect the understanding of the parties. And then also in that annexure, what you will be saying is explaining what you want to capture and then the code below that. That's the way it really works. Because if you just have your code, then people can say that, okay, this is not what I interpreted, the code doesn't reflect our actual understanding, so, you know.
We'll take a couple of more quick questions.
Yeah.
Just make it quick.
Okay. See, if you see in blockchain or technologies, we'll not have any central authority, right?
Correct.
So that will be one area which will be of most importance, because under Contract Act also you will, province, whom you are holding accountable.
Correct.
So will that become a question? Because now this is a peer-to-peer transaction.
Right. No, of course, that does become a question, because if you don't know, see, but by the end of the day, even if it's completely decentralized, there will be parties to the contract, correct?
There will be two parties. That is peer-to-peer.
Peer-to-peer. So two parties to the contract, that's what I'm saying, you're just doing it in a different way, okay? So if you have two parties to the contract, if someone is defrauding the other, or if there's a breach by one party to that contract, then the remedy still lies.
Okay, so that will not create a problem.
That should not create a...
And
of course, there will be challenges. There will be challenges, because once you go to a court to interpret all of these things, I guarantee you it's not going to be easy. And it won't be easy for a short period of time, absolutely.
So mostly it will be going through standard form of contract. That is what will work.
Yeah, a mixture, a wrapping.
We just have two more questions.
I don't know if I missed it when you mentioned, if you mentioned.
Sure.
So, in your experience, did you implement any smart contracts with your clients or somebody?
Well, I've been advising people on it. I think we're still, there are a few clients who have been implementing smart contracts more for payment gateways rather than rent
So,
agreements.
what are the main challenges that you're seeing there?
See, luckily for now, the only time you look at a contract is when it's in dispute, honestly, okay? These contracts are new, no one's really disputed them. So they haven't been challenged per se. So if you're asking, has there been a litigation in this scenario, and whether there's a live example which I can give you in court right now, answer that is no. Because that's, in my view, hasn't yet happened. Or at least I don't have that information which you're asking for.
Hi, Ashish Shetty here.
Hi, Ashish.
I understand that you are at sort of the forefront of advising clients of how blockchain smart contracts can be adopted. But in general, in the fraternity and the judiciary, what is sort of their view of how to adopt this technology?
Well, actually, if you ask me what's the judiciary view, it's too nascent. Okay, I'll tell you why. Right now, there are only a handful of law firms which have really been looking at this. This hasn't, and these are corporate law firms like us. It really hasn't even been trickled down to counsels, litigators, lower court lawyers, because they're the ones who are going to argue this matter. So this concept really hasn't even hit that level. So when they haven't understood it, for the judiciary right now to have a view on it, I think it's too young, it's too nascent, it hasn't happened. In my view, because of our interactions with regulators, and again, given that we're lawyers, we've interacted with judges, no one's really formulated a view. It's more, there will only be test cases once there's a dispute, right? And when that comes up, we'll understand as to the way in which the limitations for execution, the limitations with interpretation of code. I think that's where it really has to be tested at judiciary, which it hasn't yet been done. And until that's done, and until you get a view from a judge or a regulator on this, all of us will presume what the outcome can be based on existing jurisprudence. Like what have I told you today? I've told you smart contracts are enforceable. The reason why I'm saying that is not because I have a judge from a high court which has actually ruled on this. But the reason I say that is because these smart contracts, or what we plan to execute, have the basic premises and basic tenets of what is there under my Indian Contract Act. And therefore, you make an analogy saying that this is why the smart contracts have to be enforceable. So,
Hi, I'm Jagdish Pandya. We are supporting ICOs at incubation or accelerated stages. And my question to you is, can an Indian investor with verified KYC and AML wallet with Indian exchange participate in an ICO which is by an organization in a country which is ICO friendly, like Switzerland, Estonia, Zug, over? What is your perspective on this? And if any consultancy required for our...
See, it boils down now. I understand you.
Okay.
Basically, what's happening is because our regulations do not speak about ICOs, and effectively we do not have... See, every time you're investing money into our country, basically in India, you're regulated by SEBI or the RBI, whether it's an NBFC registration, collective investment scheme, or an AIF. Okay, so when you're raising money, but you're raising money offshore, correct?
Yeah, my client is raising offshore, and my question is, Indian investor with KYC AML verified Indian exchange account who has purchased, who has changed his fiat currency to cryptocurrency, and now we want to send this crypto abroad.
Yeah.
So,
the answer to that, what I would say, I'd be a little cautious, but what I would say is that, we have manner in which we can remit money offshore. We have your FEMA regulations. Okay, so under FEMA regulations, you can remit up to 250,000 offshore.
but
Correct.
that's investing in equity, not
In
on
equity.
tokens. We are not providing any equity, right?
Correct, but it depends on how it's being viewed in that jurisdiction. So is it a security per se under that jurisdiction, or is it a
So
commodity?
that jurisdiction is taken care. Like over there, it's not illegal to do it.
Right.
My question is, somebody has already purchased a cryptocurrency. Why
In
is
my view, the
KYC?
answer is no, it's not illegal. It's not illegal because you're allowed to remit that money.
Okay.
Now the only question is, the RBI will
Yes.
the RBI will question you as to whether it's a bona fide business purpose as to why you remitted that money.
To the person who is investing in ICO.
Yeah.
That's the current status according to you.
Correct.
Okay, thank
so
you.
it's a very bona fide business purpose as to why you're remitting this money, because you're permitted to remit money